Welcome, ladies and gentlemen, to yet another teleconsultation organized by the Asian Banker. This time we want to address this issue of FATCA, the dilemma and the issues and implementation challenges for Asian banks. I am Fu Boon Ping, the Managing Editor of the Asian Banker. It gives me great pleasure to have two specialists on this topic on our panel today to share insight on the latest on FATCA implementation and its impact and ramification on banks in Asia Pacific. Now, today's session is brought to you by the Risk and Regulation Working Group of the Asian Banker. This is a member-based program to help financial institutions track trends and identify emerging risk management best practices in the industry. The program delivers in-depth market and strategic research and insight in the forms of individual bank profiling, benchmarking research note, interview, survey, and case studies. Now, today on the panel, we have Philip Rod. Philip is a financial services partner specializing in risk advisory services from Ernst & Young. And we also have Carl Egbert, the national partner from law firm Decade, who is based in Hong Kong. Let me do a brief introduction of the topic before we invite Philip to give us his presentation. Now, financial institutions have been grappling with the issues and challenges of FATCA implementation in the past 2 years. Since the law was enacted by the Obama administration to effectively combat tax evasion, estimated at about $100 billion a year, that has imposed enormous burden on financial institutions as they struggle to comply with the FATCA deadlines. Presently, the deadline has been postponed to January 2014 for banks to comply with, and January 2017 to start withholding taxes. But that delay in implementation does not mean that banks can relax. Against the backdrop of the recent $1.9 billion settlement between the regulators in the U.S. And the large global banks for money laundering violation, we see the determination of the U.S. regulatory bodies to reform the banking industry, as well as to bring to task errant banks. So perhaps it's not a time for banks to take their foot off the pedal. Now, FIs are currently at various stages of implementing compliance measures and systems. Some have also come up with ingenious ways to minimize the impact of FATCA on their organization with their respective pros and cons. Now, key issues that we want to discuss today in our teleconsultation session is understanding what the present regulatory constraints and area where FATCA will vitally impact your financial institutions, how intergovernmental agreements between U.S. and markets in Asia Pacific will affect the obligation of banks under FATCA, practical steps that financial institutions can take to comply with FATCA effectively and competitively. Now, before I introduce Philip, let me give you some ground rules somehow on how you can participate in today's teleconsultation. If you have comments to make or questions that you would like to ask, now there are two ways that you can participate. If you refer to your WebEx screen, there is a panel on the right. If you would like to speak, please indicate on the screen, and we'll open the line for you to speak. Alternatively, you can write down your question or your comment on the chat box below, and we will ask the questions on your behalf. Now, on that note, I'd like to introduce Philip Rod. Again, he's the partner financial services risk leader at Ernst & Young in Hong Kong. Now, Philip has 22 years of experience in audit and advisory services. Prior to joining Ernst & Young, Phil worked for 8 years at a large U.S. financial institutions. Philip?
Yes.
Okay, great. I'd like you to make your presentation. Thanks.
Thank you very much, and thank you very much for the opportunity to talk to everyone today. I'm very interested to discuss some of the practical implementation challenges which institutions are facing across the region. What I'd like to do first is look at the market landscape. So if we could turn to the next slide, please. Thank you. So I think a lot of the practical implementation challenges actually originate from where we are in terms of the market landscape right now. So I think it's worth just spending a couple of minutes assessing that. So we are seeing some momentum gathering pace across the region. If you look over the last 2 years or so at implementations, I think initially it was very much the large multinational financial institutions that were taking the lead, starting off performing their impact assessments and then starting the implementation process. And for a long time, there wasn't really much activity from local institutions in the countries across the region. But I would say that has changed a little bit over the last 3 or 4 months, and we are starting to see more activity from the local financial institutions. And we'll talk a little bit about the different countries across the region in the next couple of slides. One of the challenges is obviously the fragmented market in terms of regulation across Asia Pacific, across the region. So very different from the US obviously, but also Europe, where some regulations are EU-wide regulations. I think if you look at the markets across the region here, it's very diverse, and the regulatory requirements, be they in terms of privacy or onboarding requirements from a KYC AML perspective, they're quite different from country to country. And that has a direct impact on how you can actually implement FATCA within a financial institution. Also, there's obviously a large degree of variety in the maturity of the financial markets in different countries, and we're seeing that in terms of awareness in countries, FATCA awareness, and overall awareness amongst the communities. The fourth point I'd like to mention is that because of the different regulatory requirements, some exit strategies may not be available for regulatory reasons in some countries. So as we start getting into the implementation phase, when we're talking about recalcitrant parties, a lot of institutions are grappling with how do they actually deal with them going forward. Do they try and close out the customer relationship, or do they continue and apply withholding? So exit strategies may differ from country to country depending on what the actually regulatory requirements are. And lastly, there are obviously 4 countries listed on the FATCA grey list. So in terms of the amount of reliance you can place on local onboarding procedures, they may need to be reassessed for those countries in particular. We turn to the next slide, please. So here we've just tried to summarize where we are across the region from country to country. And obviously this is a broad view. There are individual institutions in each of these countries that may be at different stages. But if you look across the region, Hong Kong, Singapore, Japan and Australia, I'd say where the most work has been done. So the larger institutions in those countries have already conducted their high-level impact assessments, and they're moving into implementation phase. However, there may be smaller local institutions in those countries which are just actually getting started with their impact assessment. But I would say in general in those countries there's a relatively high level of FATCA awareness in the market. Taiwan is an interesting case because there are a relatively large number of US persons expected to be in the market. So that will have an impact on how institutions actually implement FATCA in that particular market. In Korea, I think we're seeing a bit of a wait-and-see approach at the moment from institutions. There was some initial activity, but I think now most institutions are waiting to see whether the government actually enters into an IGA in that market. China is probably a market which is of high importance to a lot of people on the call. There have been certain high-level announcements over the last couple of weeks on FATCA, but I think if you look through some of the individual discussion points, there has been an overall theme to say that in China they will look to achieve a mutually cooperative solution to FATCA. In the Philippines, we're seeing the business community is quite mobilized around FATCA, but I don't think any significant implementation plans have started yet. And then if you look at some of the ASEAN countries such as Indonesia, Vietnam and Thailand, we've seen relatively little activity in those countries so far. And the reason I wanted to mention the overall status is if you're a Pan-Asian financial institution, the actual level of awareness in each of those countries is going to have a big impact on how you can actually implement that across the operations around the region for yourself. Okay, can we move to the next slide, please? And one more. So in terms of the actual practical implementation challenges, some of these challenges that we've listed out are common across all complex projects, but I would say particularly in terms of number one, the size of multiple locations of Asian businesses. What we're seeing with the larger institutions across the region actually having that project management approach so that you can make sure that you get a consistent implementation for FATCA across the region is definitely challenging and definitely requires strong project management at the regional level. Another practical challenge we're seeing is there's quite a large variety of systems architecture. So particularly when you start looking at the client databases, again, if you're a multinational financial institution, quite often client databases are different from country to country. Insurance institutions, quite often they have a policy master file which is different from country to country. And actually coming up with an implementation plan which goes across all of those systems can be quite challenging. One of the third challenges in terms of business models within the group, when you consider things like institutions that are dealing with asset management businesses, quite often you see the business model will change from country to country. So the roles and responsibilities of the distributor, for example, versus the fund administrator may vary from country to country. So in those kind of situations, it's difficult to come up with a one-size-fits-all solution across the region. And you really need to start to get down into the detail of the roles and responsibilities in country to come up with a practical solution for FATCA implementation. Another challenge we're seeing is education and communication. As I mentioned earlier, there's a wide variety of level of awareness in general in different countries across the region. But as you go about the actual implementation process, it's very important that you have a consistent level of understanding for all of your entities across the region locally, so that when you get to the actual implementation phase, they have a common understanding of the overall objectives of the program. What we've seen quite commonly is typically an institution will undertake, say, an impact assessment, first of all, to identify which are the high risk or high impacted countries, high impacted customer segments, business processes, products throughout their institution. And to actually conduct that assessment effectively, the people actually going through the process, typically this might be done through a workshop or a questionnaire process. The people actually going through that process need to have a very good base knowledge of FATCA before they start the process. Otherwise there may be misunderstandings about the overall objective of the process, and the actual implementation impact analysis may not be as useful as you might want. The fifth point I've listed is some of the legal restrictions around the region. From country to country there are different privacy restrictions, And what we're seeing is that might actually impact the way an institution can actually implement their FATCA program, because the level of work that might be able to be done at a regional level versus a local level might be dependent upon those privacy restrictions. And whilst it might be more effective and you might get a more consistent approach if you can try and leverage regional processes as far as possible, that might not be actually be practical in reality. The sixth point I noted is changing FATCA rules and regulations. Or obviously, we have the draft regulations at the moment, and we're expecting the final regulations to be issued within the next week or so. Some work has been done throughout institutions based on the draft regulations that we have, but it's been very, very important to make sure that assumptions that are made throughout the process are actually captured, so that you can go back and revisit those when the actual final regulations are issued. The seventh item I mentioned was navigating in a non-FATCA compliant environment. And this is, I think, very specific to Asia Pacific, the region here. When we talk to our colleagues in the US and Europe, a lot of the decisions that clients are making around FATCA and how they implement and changes to their business processes are based upon the assumption that the majority of institutions that they actually interact with on a day-to-day basis will actually become FATCA compliant. But now if you look at the overall level of awareness and the timeline that we have remaining to actual implementation, I think there's a high likelihood that a significant portion of institutions across the region will actually not become FATCA compliant by the implementation deadline. So then that poses specific challenges to those FATCA compliant institutions that are operating here, where you have business relationships with non-compliant institutions. How do you treat those going forward? Do you wish to continue doing business with those? Do you wish to limit the level of business that you do with non-FATCA compliant institutions? That's a very challenging question to go through, and it will definitely have to be assessed on a case-by-case basis for each of those institutions. The eighth challenge I've listed is actually looking at the skills and knowledge required for implementation. I think most of us operating in the region are quite familiar with the fact that quite often people have 2 or 3 day jobs. So given the level of resourcing across the region for some of the multinational institutions, multinational financial institutions, quite often people have multiple responsibilities already. So how do you actually work out how you can resource this practically going forward? How do you work out, how do you build up that overall level of knowledge within the institution so that you can implement consistently? Overall, point 9 is talking about the cost per investor. Overall, probably the number of US persons in the region is relatively low compared to, say, in Europe. But the overall cost per FATCA investor is likely to be high. And obviously we have the continual challenges in terms of the IGA developments, which we'll be talking about slightly later. In some ways, IGAs are a bit of a double-edged sword because they can definitely assist in your implementation process. However, they do take away some of the homogeneity that we had before. So when you're operating in an environment where certain of the countries where you're active do actually sign IGAs, but others do not, that will present certain challenges to the project team in terms of how you implement your solutions across the region. Thank you. We'll move on to the next slide, please. So I've listed down here a few of the operational challenges, which I'm not going to go through one by one, but I can pick out maybe a couple of those. In terms of tax operational challenges, obviously this is a tax law. The actual implementation, as we all know, is much more operational than tax-based. But there are still obviously very specific technical tax questions related to the implementation. So for the institutions operating in the region here, one of the questions is, how much access do you have to the right level of tax expertise in each of the countries that can help you with the interpretation of those requirements. Under compliance, we talk about KYC policy and responsible officer. So as I mentioned earlier, KYC policy may vary from country to country. You may have an overall group level KYC policy, but how that gets implemented may vary. So that needs to be assessed as you're going through the actual FATCA implementation. How much can you actually rely on that onboarding process, and how much you need to vary from country to country. There's been a lot of discussion about who the responsible officer will be. I think there's a level of ambiguity there. So some institutions seem to be going down the route of having compliance take overall responsibility. In other institutions, it seems to be the COO, and a third option may be the CFO. However, I think the actual implementation we will see in practice will be very similar to what happened from a SOX perspective for those US listed entities, whereby an overall responsibility tree was developed so that there was a sign-off at the base level for each individual business unit and country, which then treed up to the overall responsible officer. So I think institutions tend to be going through that thought process at the moment as to who the responsible officer will be. Under technology, I've listed data, availability, and quality. One of the challenges I think most institutions are facing at the moment is that FATCA is clearly not operating in isolation. There is a lot of other regulatory change going on at the moment, be it Dodd-Frank, the US institutions, or European equivalents, or local changes here, such as OTC, CCP implementations across the region. And most of those regulatory change programs actually rely a lot on data availability and quality, as will the FATCA implementation. So one of the challenges that FATCA implementation teams are facing in practice is, where are you in the queue in terms of what IT changes you need to be made? How can you get access to the right level of data? And that needs to be thought through for each institution. So there I've tried to highlight some of the high-level practical challenges which institutions are facing across the region. I think the next topic we were going to discuss was IGAs, so perhaps I could hand over to Carl now.
Okay, Philip, thanks. Okay, now today we have a full house. We've taken up all the spots for people to register and call in, so the response will be overwhelming. Now, Philip, before you go, I think there was one question from one of our callers. How many ROs are expected from the FI? Would it be one RO for the whole banking group, or one RO for each separate legal entity?
I think what we'll probably see in practice is one RO for each entity to enable the overall group RO to sign off. But we'll see as we work through the implementation process. But that's my personal viewpoint.
Okay, great. Thanks, Philip. Okay, next we have Carl. Carl will share some insights on IGA. Now, Carl is a registered foreign lawyer in Dhaka, Hong Kong's office. He advises mutual funds, closed-end investment companies, hedge funds, as well as US funds and offshore funds on regulatory, corporate, and business matters. Carl, over to you.
Thank you. Yep, thank you. Could we advance 2 slides, please? Okay, so Philip has given us a pretty detailed idea of the work that needs to be done. I'm going to back us up a little bit and just give a little bit of an overview of how FATCA works in the most ridiculously simplified manner possible. This slide is about what I call the 5 stages of FATCA. And they roughly translate to the 5 stages of grief that people have, because you first face anger, then rejection and denial, followed finally by understanding and acceptance at the end. The first step is if you're a foreign financial institution, which every bank is going to be, you need to determine your status under FATCA. And what does that mean? Well, it means that some institutions are going to find themselves deemed compliant. There are two ways to be deemed compliant, though. One is you can be deemed compliant in FATCA's regulations as they're written right now. But the exemptions in FATCA's current regulations are awfully narrow, and they're not always useful. And we'll talk a little bit about some of the limitations of the exemptions as they're written. The second way you can be deemed compliant is if the jurisdiction where the financial institution is organized enters into an intergovernmental agreement, an IGA, with the U.S. And under these IGAs, you can create tailored deemed compliant categories, categories that might fit a little better with local market practices and the products and entities that are on the ground in each jurisdiction. That sounds great in practice, but as we've seen so far, it might be limited because the IRS and the U.S. Treasury have so far been very conservative in allowing people to tailor FATCA to local needs. So that's that first step, is really figuring out who you are under FATCA. The second step is if you don't, you're not deemed compliant, then you're going to need to enter into agreement with the IRS by the deadline, and that deadline is really now next year. But that too might be a little bit of a moving target. And it's if you don't enter into that agreement, that's when you become non-participating, and that's when you could be subject to that 30% withholding tax. I know we're all familiar with this 30% withholding tax, but I want to make this point clearly. That 30% withholding tax applies to you if you don't enter into the agreement with the IRS, or you don't find another way to get carved out of this requirement. It doesn't matter whether you don't have U.S. shareholders or U.S. account holders or U.S. investors. Really all that matters is that you enter into the agreement and that you follow FATCA's due diligence requirements. That's the central part of this law, and not really anything else. It's ostensibly about finding U.S. tax evaders, but really what it is, it's a massive KYC process. So that's step two, is entering into that agreement. And then step three is, under the agreement will specify how you need to search your accounts for U.S. indicia. And that ties in with that list of all the operational tie-ins that Philip had in the other slide. Step four, only if you find U.S. indicia, evidence that certain account holders might be U.S. persons, U.S. taxpayers, then you need to get more information, and this is a second step of due diligence, another level of due diligence, if you think people might be U.S. persons. And FATCA pretty much specifies how you do this, and that itself creates a problem. It creates a pretty clear decision tree, but you might not really like where you have to follow this decision tree to, in terms of asking people relatively personal questions. And then kind of the fifth stage is reporting, or if you have to, withholding against people that don't provide you information. So those are what I call the 5 steps of FATCA. Really, though, all I'm going to talk about is this first step and focus on the IGAs. Can we please have the next slide? Okay, this is just the definition of foreign financial institutions. At this point, I think most people are familiar with it. Banks are clearly covered in the first prong of the definition, but also a lot of the products that you offer will be covered by the second and third prongs. Second seems to be financial trusteeship relationships, and the third prong seems to be most collective investment vehicles. Next slide, please. Okay, I sort of answered this before. Even if you don't have any U.S. account holders, does FATCA apply? Yeah, FATCA applies. It does become a little bit of a question of what the IRS can do to you, but because FATCA is focused on whether you have followed the information gathering or tax withholding process, that's all that matters. It doesn't matter whether you have U.S. account holders. Next slide, please. I don't invest in U.S. securities. My accounts don't have U.S. securities. I don't think I'm going to have any U.S. source income, and that 30% withholding tax only applies to U.S. source income. Will FATCA still apply? Yeah, we think the answer is yes. There's no carve out for financial institutions that don't invest in the U.S. But the IRS and the U.S. Treasury won't really have a hammer to hit you, because they won't be able to apply that 30% test. But I wouldn't get too comfortable, because even though they can't apply the 30% withholding, this means you can never invest in the U.S., and you might want to at some point. And there's also the risk that other financial institutions aren't going to want to risk their own status under FATCA to deal with you. So it could have a very isolating effect for institutions that can't comply. Next slide, please. Okay, and then these are some of the deemed compliance. We're going back to the 5 steps of FATCA and figuring out who you are and where you fit in under FATCA. Deemed compliance, there are categories for financial institutions that have entered into IGAs. There are categories for local banks, retirement plans, qualified investment vehicles, and restricted funds. The problem with these categories, though, is they are unbelievably restrictive, and frankly, they're designed with the U.S. market in mind. When the U.S. regulators were coming up with the draft regulations, it was clear that they didn't understand exactly how things worked outside of the U.S. An example is the local bank exception. This sounds great if you have a bank that operates only in one jurisdiction, and it's a relatively small size, and it has a local client base, then it can be exempt from FATCA. That's exactly the kind of smaller institution that is going to really struggle with FATCA. And so this exemption on paper looks great until you start looking into the details. For example, local banks can't advertise the availability of U.S. dollar deposits. In Hong Kong, at least, when we surveyed the banks about who offered U.S. dollar deposits, it was basically everyone. So even the smaller local banks offered U.S. dollar deposits, and in fact, you'd be crazy not to. So the local bank exemption under the FATCA's regs is not particularly helpful. Next slide, please. Okay, so the cooperation agreements, what do they do for us? There are benefits, and one of them is there's a decreased scope of withholding on entities that are in cooperating countries. Generally speaking, you're not going to need to withhold against account holders or other financial institutions in those countries, although there is a process to decide that a financial institution in a country is not compliant and they can get kicked out. But nonetheless, that is a benefit. The second major benefit is tailoring FATCA's exemptions to local needs. And that particularly comes in handy when you're thinking about retirement funds, retirement plans. For example, in Hong Kong, the mandatory provident funds have a couple built-in features that are enshrined in law that simply conflict with the deemed compliant categories that are offered in FATCA. There are certain limitations in FATCA on how much money you can invest in a retirement plan and be exempt from FATCA. The limits aren't the same outside the U.S., and in fact they vary from country to country, and MPFs in Hong Kong have a different limit. So the FATCA exemption for retirement plans doesn't work. However, we think that the IGAs are going to be successful in finding exemptions for most local retirement plans. Will we see cooperation agreements in Asia? Well, as Philip mentioned, there's a number of jurisdictions that are talking with Treasury, and they include Singapore, Malaysia, Korea, Japan. India is looking at it. Just had a discussion about a meeting last week in Indonesia. Indonesia is still trying to decide what to do. I think the feeling from a lot of local financial institutions there is that an IGA would be helpful, but the government is still trying to sort that out. What about Hong Kong and the PRC? To a certain extent, whatever we say about the PRC is going to be speculation. We've seen conflicting signals from the government. Last year, they said they were very interested in FATCA and looking at it. This year, we heard that they didn't send a contingent, a delegation to one of the meetings on FATCA because it wasn't in the budget. So these are very strange messages, and they're conflicting messages. My guess, though, is that the PRC absolutely will find some way to cooperate, and I think that's in line with what Philip said. Hong Kong also has a bit of a tricky situation. We have data privacy laws that are considered to be very important and that really have only recently been enshrined in law here. And it's not clear if LegCo, if the legislature here will approve changes to these laws. But there is a chance, and that chance will probably come in early spring next year, when other changes to the data privacy laws are up for a vote. And so there's a window for us to pass through these changes. It's unclear whether the government will be able to do it. It's not clear whether we'll have their support. But I think an IGA really makes sense for Hong Kong, and I think that people are willing to look at it and willing to give it a try. But we won't know whether Hong Kong can enter into an IGA until after the legislation gets passed. So it's going to be, as I said, early spring at the earliest before we know whether Hong Kong can enter into an IGA. Next slide, please. Okay. Philip mentioned that the agreements are a bit of a mixed bag, and I agree. I think with one benefit of FATCA is that it is one size fits all. One major disadvantage of FATCA is that it's one size fits all, and it just doesn't seem to fit a lot of the jurisdictions in Asia. For the banking industry in particular, I think it makes a lot of sense. For one thing, the IGAs give you a margin of error for sort of administrative or inadvertent noncompliance. And they clarify that you won't be kicked out, you won't be penalized just for inadvertently making a few mistakes with FATCA compliance. And my guess is there are going to be a lot of mistakes because it's a tremendously complicated law. The IGAs are also helpful because they allow you to use a lower threshold for some of the due diligence. For example, FATCA requires that you treat an entity as a U.S. entity, and then therefore you have to get additional information or withhold against it if more than 10% of the entity is held by U.S. persons. Now, the problem is, of course, we've never collected information about whether an account holder is held by only 10% U.S. persons. When we're conducting AML checks, typically we're using a 25% threshold unless we've seen some other evidence of anti-money laundering. Then we might go down to 10%. But under the IGA, you can treat an account as a U.S. account only if it's controlled by U.S. persons, and I think that's going to be a much higher threshold, at least 25%. The other benefit is there's no need to withhold tax against non-consenting accounts. Next slide, please. I think the best feature of cooperation agreements that might really hold promise in Asia, and it's still going to need a little bit of work, is the local foreign financial institution exclusion. As I mentioned, the existing FATCA regulations contain an exemption for local banks, but it doesn't make sense. You can't advertise U.S. dollar deposits. You have to have less than U.S. $175 million in assets. That's just not possible. The IGA takes those restrictions away. There are a few problems still, though. A local financial institution can operate only in its home country. So that's still a pretty high bar to reach, and especially if you're in Hong Kong or Singapore, essentially city-states where most financial institutions have to, by necessity, operate outside of the borders of the cities. Another requirement is at least 90% of the accounts by value must be held by residents. That's also a fairly high threshold. Be interested to hear from all of you, though, if you think that this kind of exclusion would be helpful in your various jurisdictions. If it is, then I definitely would love to hear about it. We are actively lobbying in a number of jurisdictions to try to beef up this exclusion and make it more useful for institutions in Asia. Next slide. Okay. What do you need to do? Well, the agreements with U.S. authorities, if you don't enter into an IGA, need to be in place by the end of 2013. That has been changed from the sort of soft deadline of June 30, 2013. But I'm not entirely sure that we should just be focusing on that top-level deadline. There needs to be a lot of work that is done before you enter into the agreement, and just surrounding all of the compliance build-out and the infrastructure build-out that's necessary for FATCA. And as I mentioned here, we've seen that FATCA compliance is achievable, but it takes a lot of time. It can take up to 2 years. Next slide, please. And this is the IRS circular disclosure that we have to disclose so that I don't get into trouble. But now I think Philip and I can take some of the questions from the audience.
Okay, thanks, Carl, for the comprehensive overview. Now, we have a big number of questions that have come in. Philip and Carl, I wonder if you can see those questions appearing on your screen. Okay, I'm just going to ask them on behalf of the callers. We have a caller. Now, who asked, if a Malaysian banking group has a branch in the U.S., would it mean by default that the group has to enter into the agreement with the IRS?
It's actually not going to change the analysis too much. If you are a bank and you are outside the U.S., then you need to enter into an agreement with the IRS or the Treasury, or find yourself subject to a cooperation agreement. Whether you have a U.S. branch, a U.S. parent, all of those things, it's not particularly going to change the analysis. If you actually were a U.S. business, then you wouldn't necessarily be subject to FATCA per se, although that's not necessarily a big help, because then you'd be subject to a plethora of other U.S. regulations.
Okay, now assuming if the Malaysian banking group do not enter into agreement, do they need to close down the branch in the U.S.? What are the alternatives?
They don't need to close down the branch in the U.S. The thing is, they're likely to find themselves subject to FATCA in other ways. The branch in the U.S. isn't going to be the trigger. So it's the real trigger is, are they a foreign financial institution, and will they have any investments, or will they have any dealings with anyone that might produce U.S. source income? And if the answer to both of those questions is yes, then they're subject to FATCA regardless of what they do with the branch in the U.S.
I think the main thing is that if they don't enter agreement, they'll obviously be withheld upon on the U.S. source income, as Carl mentioned. And as other financial institutions start to go through and analyze their relationships with counterparties, we are starting to see some institutions make the decision that do I want to continue dealing with non-participating FFIs? So it may be difficult to operate from a business perspective without actually entering into that agreement.
Now, for financial institutions, now they can either individually enter in the agreement with IRS, or they can report or be subject to their local authorities through IGAs and stuff. Could you share with us what are the progress on IGA discussion? And Carl, you mentioned Hong Kong is probably will be having IGA. What about the other jurisdiction? And what about those countries in the gray list? If you can share insights on those. Thanks.
Well, we know Japan, we know Korea, Malaysia, Singapore, even India is working for some way to engage. So those are the jurisdictions that have been publicly announced. We know that not every jurisdiction that is working hard on FATCA has allowed the IRS or Treasury to publicly announce it. So just because a jurisdiction hasn't been mentioned on that list that Treasury published, it doesn't mean they're not working at it. But it's, for say Vietnam or Indonesia, it's a little early to tell, I think, because I think they're only now starting to really get their hands dirty in terms of figuring out what to do with FATCA.
So for institutions in those jurisdictions, what is the best way forward? Obviously, is to do that first to start doing the impact analysis. And now, what do you see happening first? The IGA coming before the implementation deadline? And
we expect IGAs to come in before the implementation deadline in pretty much all of the jurisdictions I mentioned, with the exception of India. If your jurisdiction isn't on that list, I think you have to be safe, you have to start a two-track approach to compliance. And if that means, and the good news is the two tracks aren't always that different. But for certain institutions that think that they might be deemed compliant and they might have an out from FATCA, they might want to just focus on the obligations that they'll be subject to, regardless of whether they're deemed compliant. And I think we should have made that point earlier. Just because you're deemed compliant from FATCA doesn't mean you have no obligations under FATCA. You could still be subject to some review of your accounts and some obligations. So, you probably need to take a two-track approach. The best thing to do, though, is try to engage with your government, try and get a sense of what they want to do. And in places where there aren't necessarily hurdles in legislative hurdles, and where the government is able to decide on policy quickly, I think you might be able to trust in what they say. In other places like Hong Kong, where it is an open question whether this will pass LegCo, I think you absolutely have to take the two-track approach. I noticed one of the questions was, can Hong Kong wait for China to enter into an IGA? Unfortunately, in this case, Hong Kong and China are separate entities, and that's because, although it's one country, they are definitely two tax systems.
Philip, anything to add?
No, I absolutely agree with Carl's comment. You have to have a two-phase approach. So you have to have a backup plan in place if the IGA does not get signed in time for the implementation. That's the only solution I think FFIs can take.
Okay. Now, Philip, in one of the charts you mentioned the different, where we are at in terms of awareness and actions. Do you see actions in some of these markets? like the Philippines, Indonesia, Vietnam, Thailand, picking up in the subsequent months before the deadline looms?
Yeah, I think we are starting to see more activity in those markets. For example, in Vietnam, we're just talking to a bank today about potentially helping them with their FATCA program. So I think it's definitely starting to gain momentum. It's just given the time frames involved, you have 1 year left to implementation. It's a case of how many of the institutions in those countries can actually get ready in time.
Okay. Now, how much of their current processes do they need to change? Now it says it can build on the existing AML processes how much more real cost and efforts do they need to be compliant?
Sure. Usually the first couple of phases of the implementation program, one is actually a legal entity analysis. So going through each of the legal entities within your group, which would include things like funds, for example, and determining whether they're FFIs or not. So you need to go through kind of a decision tree process. So that's one phase which people are going through. And then the other thing which is generally accelerated in the program is looking at the client onboarding procedures for new customers, because that's one of the first requirements that becomes live on January 1, 2014. So as you mentioned, the question is how much of that can you rely on existing AML procedures, and how much do you need to enhance to make sure that you're FATCA compliant? One of the questions that Carl brought up was for entity onboarding, for example, what level of beneficial ownership are you assessing at the moment in your current procedures? Are you assessing to the 10% level, or are you assessing to the 25% level? So doing a gap analysis really on the onboarding procedures for each country, for each business line, for each customer segment, and identifying what changes need to be made is something that needs to be prioritized really right away, I would say.
Oh, Carl, one of the questions that have come in, one of the objectives of IGA is to overcome legal impediments in certain countries. For countries with no legal barriers, is there no need for IGA?
I'd say an IGA still has some benefits. As Philip was just mentioning, there is this difference between when you look at the beneficial ownership of accounts held by entities. You need to look through to 10% U.S. owners under the standard FATCA regs. Under the IGA, it would only be whether the entity is controlled by a U.S. person. Actually, there's an even more extreme example. If you have an account that is held by an entity that's essentially a financial services entity, if it's held by even one U.S. person, it could be treated as a U.S. entity and therefore a U.S. account. And we don't necessarily have the processes in place to try to find these kinds of entities that are held by just one U.S. person. So that's an example of how an IGA could, at least in theory, be tremendously helpful. I think the IGAs are also helpful, at least at this stage, because they spell out what your obligations are maybe a little bit more clearly than the current FATCA regs do, although that might change when the final regs finally come out. The IRS has been saying that the final regs are coming out in the next few weeks. The only problem is they've been saying that for the last 4 months.
Okay, we have another question. For foreign financial institutions dealing with foreign privacy laws that do not allow information of customers to be shared with outside party, how do you deal with that? Carl, would you like to take that question?
Sure. In a lot of the jurisdictions where there are data protection rules, they will allow the information to be released upon consent to the clients, but that consent can't always be obtained. And if you just have a blanket prohibition on releasing the information, and at the same time you have an obligation under FATCA, then you're really in a bind, and the only solution is an IGA. I think it is possible, though, that there are going to be some countries that won't be able to enter into IGAs that have these conflicts and that won't be able to get waivers or consent from clients. Treasury has recognized that there's just certain regions of the world and certain countries that will not be able to comply with FATCA. And I think in that kind of situation, it probably will mean that you need to pull out of U.S. assets, and that's about all you can do to protect yourself. And you can also try to ring fence the accounts where this is going to be a problem, if it's only specific accounts and not others. But that is a real problem, and the only solution that I think works on a broader scale is an IGA. And if that doesn't work, I think this is one of those areas where FATCA is still very frustrating, and we're going to need to work harder to find a solution.
Okay, Carl, next question is very specific. Implication of proposed regulation section 87.1. When is it going to become effective?
I'm not sure what 87.1. Could whoever posted that question clarify what they're looking for? We'll try to take it.
Okay, we'll come back to that question. Now, a question for Philip. Philip, you mentioned in China there have been some mutual cooperative solutions to FI. Can you elaborate on that?
Sorry, just to clarify, what I was saying is that there has been public pronouncements in China which said that China will reach a mutually cooperative solution on the topic of FATCA with the U.S.
Okay. Okay, we have another question from a Malaysian bank. What are the restrictions for FATCA compliant in dealing with a non? Oh, yep. So what do you do with a non-compliant financial institutions in your dealing?
It's a little bit of an open question. Yeah, I'm sorry. Go ahead, Philip.
I was going to say just as with if you're dealing with a non-compliant FATCA institution, then you would need to withhold against that institution. And this is one of the questions that people are dealing with now in terms of looking at their business relationships with other institutions. In general, people are starting to send out questionnaires or starting to ask their business partners, what their status is on FATCA and whether they will be compliant or not, and making an assessment based on that whether they want to continue those business relationships. In addition to the practical operational challenges of withholding on non-compliant FATCA institutions, there's also, to a certain extent, reputational issues which FIs might need to take into consideration. Sorry, Carl, if you have additional comments.
No, I was just going to say, you don't know what to. There's nothing written into FATCA that says that a compliant FFI can't deal with a non-compliant FFI. It just says that if there's withholdable income, you have to withhold it against them. But we're hearing from all kinds of market participants that they feel like it's risky to deal with non-compliant FFIs. I do wonder, though, what's going to happen if you've got a very important customer and they're not going to be compliant. You don't have any U.S. source income, so there's nothing to withhold against. What do you do in that situation? It's not immediately clear, but I think the market consensus is you've got to stop doing business with them. And even if you decide that you can continue doing business with them, if pass-through payment withholding ever gets implemented, then you're going to be in a real fix, because then you'll still have to withhold against them, even notwithstanding the fact that there's no U.S. withholding, at least immediately. So I don't think there's an easy way to deal with a non-compliant institution.
Okay. Now we've got callers from, presumably from the Philippines. What's the status of IGA discussion in that country? Perhaps Phil, you can kind of update us on that. Or Carl, sorry.
I actually don't have any update on the Philippines. Had some discussions with people there earlier in the year, but that is the last update that I heard of it, and I'm not sure if Philip, you have any information.
I don't know the current status on that either.
Okay, we've got a question on now. Now, when it comes to intergovernment agreement, now which is the government agency that are leading the discussion with the IRS? Is it the tax or the central?
This is a very interesting question. If you have an active revenue department and one that is very interested in the data, then it's fair to say that the revenue departments have been getting involved in some jurisdictions. If, on the other hand, you don't have an active revenue department and you're not particularly concerned about getting this information from the U.S., then I think it's more likely to be the equivalent of Treasury in governments. As to who can enter into the agreement, I mean, that really depends country to country on their own internal administrative law. But we've seen a variety of different government agencies get involved, and in some cases it's been the securities regulators who have noticed that this creates a problem for the securities markets, and they've been pushing it along. So it really has depended a lot on local market conditions.
Okay, now we have some questions that were sent in earlier before the session. I think, Carl, this is more for you. As of today, only Switzerland and Japan will sign up to Model 3 IGA. What other countries or jurisdictions, apart from Hong Kong, are looking at Model 2? Sorry.
Yeah, I think that's actually going to be similar to the divide that I just mentioned. If you have a jurisdiction where they tax capital gains, where they tax funds, where if you have a low tax jurisdiction, I don't think, and you don't collect and you don't do any information reporting to revenue authorities, then I don't think the revenue authorities are going to be interested at all in doing the additional work that's necessary for Model 1. So I think a lot of Asian jurisdictions where information with reporting and withholding does not occur will ultimately be interested in Model 2. But there's also two different varieties of Model 1. One is reciprocal and the other is non-reciprocal. So, and then it's not entirely clear to me whether some jurisdictions will end up in Model 1 non-reciprocal, even though they're not necessarily interested in the exchange of information.
Okay, thanks, Carl and Philip. Okay, now today's session is for 1 hour. I know there are still a lot of questions coming in. Unfortunately, we are not able to address all the questions. But if you have further questions, you can send them to the Asian banker. We'll try to address them separately through Philip and Carl. Now, a recording of today's session will be made available on our website. So if you are interested to revisit some of the discussion that we are having today, please visit the website. Now, in conclusion, just a few summary points from today's discussion. Now, the FATCA regulation is pervasive and far-reaching. So for banks and financial institutions, they are widely impacted, whether you have assets in the U.S. or not. In terms of dealings with other banks, there's potential to be locked out of dealings with other banks for those non-compliant institutions. So there is a need for financial institutions around the region to do their impact analysis. The deadline for implementation is looming, so there isn't a lot of time left. Now, Carl and Philip, do you have any comments to make before we end?
No, I couldn't have said it better. I think we're.
Thank you very much for your Sorry, go ahead, Carl.
I'm probably going to say about the same thing as you were, Philip. The only thing to underscore is that it's a tremendously complicated law, and that it takes time to prepare. So whether you're in a country that's going to have an IGA, whether it definitely won't have an IGA, or whether you just don't know, I think you have to start coming up with a plan. And that it's going to be cheaper, it's going to be more efficient the sooner you start. And on that note, thank you all for listening in. And Philip?
Yeah, I fully echo your comments, Carl. It is challenging, and if you look at the reason why there was a delay in the implementation guideline and the implementation deadline, it's because the IRS realized that even if everyone started going full guns today, they weren't going to meet the original implementation date. So, I would say that I would encourage institutions to really get started now. Thank you.
Great. On that note, we'd like to conclude today's session. We thank all callers for calling in and for your participation. Until our next session,